This season of the Urban Conservative Podcast is brought to you by Newton for Senate, working to improve education, reduce taxes, and keep North Carolina #1 for business. Find out more at newtonforsenate.com. This episode of the Urban Conservative has also been sponsored by Case Technology Consulting. Help your business get value out of its data and become more efficient and streamlined. Case Technology Consulting. Check out the link in the description.
We'll hear argument first this morning in Case 21-476-303 Creative LLC versus Elenis. Ms. Wagoner?
Mr. Chief Justice, and may it please the Court, Lori Smith blends art with technology to create custom messages using words and graphics. She serves all people, deciding what to create based on the message, not who requests it. But Colorado declares her speech a public accommodation and insists that she create and speak messages that violate her conscience. This court rejects such government-compelled speech. In Hurley, the court considered a very similar issue, asking two questions. Is there speech, and is the message affected? That test is easily met here. Colorado agrees Ms. Smith creates speech, and the law undeniably affects her message. She's not asking this court to create new law, but to apply its precedent. Colorado first says this case is about a sale. It's not just about a sale. The state forces Ms. Smith to create speech, not simply sell it. Next, Colorado says it can compel speech on the same topic. But Ms. Smith believes opposite-sex marriage honors Scripture and same-sex marriage contradicts it. If the government can label this speech equivalent, it can do so for any speech, whether religious or political. Under Colorado's theory, jurisdictions could force a Democrat publicist to write a Republican's press release. Colorado's last resort is to argue that it can at least compel the same expression. But even the same expression can mean different things, like a black sculptor who carves a custom cross to celebrate a Catholic baptism, but not an Aryan church rally. If the government may not force motorists to display a motto, school children to say a pledge, or parades to include banners, Colorado may not force Ms. Smith to create and speak messages on pain of investigation, fine, and re-education. I welcome this court's questions.
Counsel, would you spend just a few minutes on whether or not this your case is ripe?
Sure. This court has considered pre-enforcement challenges before, and in those contexts, it has looked at the facts. This is one of the strongest pre-enforcement cases I think that this court has considered, in that the parties have stipulated every message that Ms. Smith would create has a unique, customized message, and that it celebrates a wedding and celebrates a marriage. It's also difficult to imagine a scenario where there isn't a more aggressive enforcement history by Colorado. Ms. Smith's speech has been chilled for 6 years. She has been unable to speak in the marketplace. She's ready to do so today, and she's ready to post her website statement today, which makes this case ripe.
Ms. Wagner, unless you're not through with that, sorry.
I'm through.
Okay.
Thank you.
Can I give you a hypothetical? It's not really a hypothetical, because I happen to have 2 clerks in my chambers this year who are engaged. So in looking at this case and preparing this case, I looked at their websites. And so the hypothetical is about, like, I'm going to call it the standard website. They both have their names on it, the date of the wedding, a picture of the couple. Then there are a bunch of places that you can click to. And one is the schedule of events, and the other is travel and hotel arrangements, and another is favorite things to do in town while you're here, and another is registry. So that's what most websites look like, yeah? And they're not particularly ideological, and they're not particularly religious, they're not particularly anything, all right? And And then there's a tagline, just like the tagline in this case, about sort of who created the website or whose graphics and design and typefaces and so forth were used in the website. And so one of them says, I'm going to substitute a woman's name just to not advertise, but one of them says, made with love by Amber, right? Mm-hmm. It's actually bigger than the 303 tagline. So I guess what I want to know is, suppose Amber wakes up tomorrow morning and says, you know what, I don't want to do those websites anymore for same-sex couples. Could she do that?
In terms of creating new websites?
No, you know, like she's providing these templates, and she has all these designs and typefaces, and that's what people use when they create their own website, because they give her the date and they give her the list of hotels and so forth. So can Amber wake up and just say, no more gay couples?
She can't say no more gay couples, but a speaker does have the ability to decide not to speak under the law. But I think the hypothetical that you're mentioning is assuming that it's a plug-and-play website, essentially, that the website is already made and that the speech creator isn't making any additions to it.
No. I mean, you know, just like, I mean, I have to think that your client does something similar. You have lots of graphics, you have, you know, typefaces, and, you know, maybe, you know, some are a little bit more you talk to the client, and some are a little bit less you talk to the client. But basically, you know, clients are coming in and they're saying, we just want a standard website, you know, that tells people where to stay and how to travel there, and you know, what our favorite things to do are. And the question is, can a website designer say, sorry, that's not my kind of marriage?
The website designer...
There's no scripture, there's no ideology, there's no nothing.
There is ideology, and this court has already recognized that there is ideology and different views on marriage, and the court's promise in Obergefell is to protect those who would believe marriage is between a man and a woman from having to express a view that violates their conscience. But
Okay, so I think that, if I understand you, you're saying, yes, she can refuse, because there's ideology just in the fact that it's Mike and Harry and there's a picture of these two guys together.
That is speech. You are announcing a wedding, and if you believe the wedding to be false, then the government would be compelling you to say something that you otherwise wouldn't say, which makes it content-based.
So it's really nothing about the content of this speech. I mean, it could be Mike and Pat, and you don't actually even know whether Pat is a woman or a man. There's really nothing about the content of this speech. Am I right? In your case, you have like scripture examples, and so that might, you know, be different, maybe. But you're being forthright and saying it's really not about that. It's nothing about the content of the speech. It's just that the content is being, whatever the graphics and typefaces and, you know, which hotels are, you know, have been reserved for the wedding, it's being used in a same-sex marriage.
No, it's not about the use. It's about when a person is creating speech, it is what is the message that they are expressing. The Hurley framework asked this court to first look at, is there speech? And there clearly is. Words, graphics, text, videos, pictures, that's speech, and it's generally protected. The second is to ask, is the speaker's message affected? And when you're requiring a speaker to create a message to celebrate something that they believe to be false, you're compelling their speech, and it's affecting their message.
So their message is not actually the content of the website. I mean, this is Justice Kagan's point. We could have a situation in which the identical website is being offered, one to Harry and Anne, and one to Harry and Steve. But everything on the website is exactly the same. I think I hear you saying that the message that the designer would be sending when she offered the website to Harry and Steve would be different and contrary to her beliefs, and that so it's the implicit message that she's endorsing that wedding that's the problem.
No, she's not. It's not about whether she's endorsing it. She's not speaking through anything but creating the speech. And when you switch out those names, you're switching out the concept and the message that is actually in the website. Think of an example
Where?
of God bless this marriage.
Suppose that we...
Well, that's a particular message. But I looked and to your proposed website, and I turned to page 51. It says, save the date, Lily and Luke, November 17, 2017. So what's the message if it says save the date, Lily and Lillian, or Lily and Mary? What's the message there?
That's an invitation to celebrate a marriage.
But why is it your invitation? I go to a wedding website. It's something that I send, meaning you, your clients. I send it to my family and friends, or Lily and Luke send it to their family and friends. You don't send it. They go to this website. You're not inviting them to the wedding. Lily and Mary are. So how has it become your message?
In the same way that it is a message of a ghostwriter who writes an anonymous press release or a book, it is still that writer's speech. The whole point of the compelled speech doctrine is to ensure that...
What's the limiting line of yours? Justice Kagan asked you about another website designer, but how about people who don't believe in interracial marriage? Or about people who don't believe that disabled people should get married? Where's the line? I choose to serve whom I want if I disagree with their personal characteristics like race or disability. I can choose not to sell to those people? This website? Because it's my speech?
Not at all, Your Honor. The Hurley framework provides that in a public accommodation context, the first thing the court looks at is the speech creator otherwise serving those in the protected class and expressing other messages? In the context of race, it's highly unlikely that anyone would be serving Black Americans in other capacities, but only refusing to do so in an interracial marriage context.
Suppose we agreed that the website designer could not refuse to provide that service to a same-sex couple if the website is of the kind that Justice Kagan described. What does that say about the particular case that is before us on stipulated facts?
Well, it would say that the court isn't considering those facts because that's not this case that's presented to them. But at the same time, even that website...
Well, so what are the differences between... What differences do you see between her hypothetical and the actual case that is before us?
She provided a number of hypotheticals. So in terms of assuming
Just
it's
one, Ms.
The
Wagner.
hypothetical
Website.
where there is a website and basically all the website operator does is to put in the names of the two people who are getting married.
That's not a service that, or speech creation that Ms. Smith provides, but if she did provide that, if it's a plug-and-play website where the couple, for example, is putting in their names and using their website, then you don't have compelled speech because you don't have a speech creator. But even in the context of putting in names...
I'm sorry, show me on your website. Show me on the pages of your petition for a writ of certiorari. Show me a page on that website that is an endorsement of a marriage as opposed to the story of a couple.
Well, either one violates the compelled speech doctrine.
No,
You
please
can't...
show me a page on your website. It's attached to your petition. I'll start you on page 51.
Pages 53, 52, 54,
Okay,
55, and 56 all represent an invitation and a
53
celebration.
says our photo gallery. 54 says funny dating story. How is that your story, your photo gallery? It's the couple's photo gallery. Page 54 is funny dating story. It's their story, not your story. I'm looking at every page, and basically it's the story of the couple. It's a date on page 51. 52 is our special day. 53 is RSVP, our photo gallery. 54 is a funny dating story. I keep looking at all of the mock-ups, and all of them relate to what Lily and Luke are saying or doing, who they are, who are their grooms, who aren't who's their bridesmaids. I don't understand. How is this your story? It's their story.
If you're asking whether, first of all, book authors, newspaper editors, those who write all kinds of publications may be writing about someone else's story, but it's still their speech, and it's
They're
still
not
protected.
public accommodations in the same way.
Ms. Wagner, can I ask you a question about a heterosexual couple? So, in response to Justice Sotomayor's questions, I took it that your website, where you say, why a wedding website, you go through, and it seems like Ms. Smith was careful to say things like, I fully customize the look, feel, theme, message, color palettes, etc. And then there's the engagement story page, and a page inspired by you and written by Lori that captures and conveys the cherished storybook of your love. So I want to ask you a hypothetical about a heterosexual couple that comes to your client. And their wedding story, that they want to write under the engagement story page goes like this. We are both cisgender and heterosexual, but that is irrelevant to our relationship, which transcends such categories. We knew we were soulmates from the moment that we met, and on and on. Would your client publish that site?
Yes, she would publish the site, because her objection, assuming that the marriage is between a man and a woman, she would publish it, and that there's no message.
Even though that narrative, I assume, is inconsistent with her biblical views about marriage. Or I'll give you another related one. A heterosexual couple comes to her, and in the engagement story part, writes a story that goes like this. We met at work. We were both married to other people. But what began as late nights at the office quickly turned into love. After 6 months, we realized we could be happy only with each other. So we decided to begin our story today, got divorced, and are marrying each other. Does she publish it?
I don't believe that she would. I also don't believe that she would embrace or express a message that would essentially say it doesn't matter whether there is a marriage between a man and a woman. She wouldn't create that speech
So
either.
it's about the message and not about the sexuality of the couple that asked her to express it that matters.
Yes, which is exactly how the court decided the case in Hurley, but it's also in other cases as well. The Pacific Gas and Miami Herald cases, this court has routinely looked at compelled speech cases to determine if the message...
And Ms. Wagner, can I just ask you to clarify before we move on? When I first asked you the question about the cisgender heterosexual couple, you said you thought she would publish it, but then it seemed like you wavered and said something different.
If I could just clarify the hypothetical, the second part of the statement was that it didn't matter. Is that?
That concepts of gender or, sexual orientation were irrelevant to their relationship because they believe that those categories don't matter. What matters is their union of souls.
No, she would not create a website that would say that, because that would violate her beliefs about what Scripture holds on marriage. In the same way, though, this law and the compelled speech doctrine protects the LGBT website designer, who won't be forced to have to create a website essentially advocating for a view of marriage that they don't hold.
Can I ask
What do
now
we-
just
what do we do-
in this?
what do we-
No, go ahead.
No, please.
No.
Justice Gorsuch?
I'm sorry.
No.
One can view these websites, or last time around we had cakes, as either expressing the maker's point of view or the couple's point of view. And that's really at the heart of a lot of this. And I guess I'm a little confused because sometimes, as I understand it, you're saying inherently here it is my client's point of view and not just the couple's point of view. I'm being compelled to speak. I get it. And sometimes Colorado agrees with you. For example, when it comes to the example you just gave, which is why I popped up. I believe it was William Jack in the Masterpiece Cake example, where Colorado said he didn't have to create cakes that spoke against same-sex marriage. That would be his compelled speech, not just the couple's speech. So what do we do about this level of generality problem, if you will, where people slide back and forth based upon their priors? How do we avoid that as a court? What rule would you have us draw?
The court should follow a rule that says if the speech is being created and there's an objection and that objection is contained in the message, it is protected speech. And the government can't slide up and down.
Tell me why it's not protected speech. The identical message that Justice Barrett put forth, but by a disabled couple. And you say, I don't want disabled people to get married. I think propagating a disability is against my personal belief. It doesn't have to be religious, because we're not dealing with the religious part of this. I don't want to speak that message. I, too, believe that two disabled people getting married and telling their story of how they got in love, I'm not going to serve those people, because I don't believe that they should be married. What's the difference between that and I don't believe black people and white people should get married?
What matters is what the objection is that the speaker is being asked to create, and whether the objection is...
But if I just, that's my objection. I don't believe they should be telling their story.
If you don't believe they should be telling their story, and what they're asking you to do is tell their story, then you don't have to do that. In
So
the
it doesn't
same way,
really, there is no line on race, there is no line on disability, ethnicity, none of the protected categories in a public accommodation law.
there is a line. There's a very clear line, and it's worked very well.
Tell me what the clear line is. It's you're saying it's compelled speech, correct? Not compelled service.
I'm saying that in the public accommodation cases, this court has routinely looked at whether there's speech and whether the message is affected and whether the objection lines up with the
But
final speech.
But the one line that you're missing is Justice Gorsuch's line. Whose speech is the person viewing it going to think is talking?
The Pulitzer Prize doesn't go to the customer or to the subject. It goes to the photographer. And there's a reason for that. That reason is because you are requiring that artist to speak a message. It is their work. It might also be the customer's, and the customer can use that. But the First Amendment is broad enough to cover the lesbian website designer and the Catholic calligrapher. The line is that no one on any side of any debate has to be compelled to express a message that violates their core convictions, because as this court found, it's demeaning to them.
So
I'm sorry.
Can I ask you a hypothetical that just sort of helps me to flesh that out? Because I also heard you suggest earlier that there's something different about race. Maybe the person wouldn't sell to someone of a different race. So suppose you say that photography is expressive. Can you give me your thoughts on a photography business in a shopping mall during this holiday season that offers a product called Scenes with Santa? And this business wants to express its own view of nostalgia about Christmases past by reproducing classic 1940s and 1950s Santa scenes. They do it in sepia tone, and they are customizing each one. This is not off a rack. They're really bringing the people in and having them interact with Santa, children, because they're trying to capture the feelings of a certain era. But precisely because they're trying to capture the feelings of a certain era, their policy is that only white children can be photographed with Santa in this way, because that's how they view the scenes with Santa that they're trying to depict. Now, the business will gladly refer families of color to the Santa at the other end of the mall who'll take anybody, and they will photograph families of color in other scenes. So they're not discriminating against the families. What they're saying is Scenes with Santa is preserved for white families, and they want to have a sign next to the Santa that says only white children. Why isn't your argument that they should be able to do that? And maybe it is.
Because in the photograph itself, the objection is not contained in that photograph. But in addition, I think it's important to remind the court that...
No, don't leave. Sorry. What do you mean? I mean, the objection, just like your client's objection, is to expressions that violate their own views of what is being depicted. And so their view of what is being depicted is that a scene with Santa and a child on the lap and all of that in sepia tone, trying to harken back to the good old days, should only have white children in it. That's their firm belief. They are not willing to take photographs of Black, Hispanic, Asian children on Santa's lap. Why is that any different than a situation like this?
Because the specific objection that you're including is not necessarily in that photograph, but even if it were, this court has protected vile, awful, reprehensible, violent speech in the past, and it is never compelled.
No, I'm just asking you, why is the objection of the web designer, as Justice both Kagan and Sotomayor has pointed out, when we look at your examples, they just say things like, please come to the wedding on this day.
Precisely. It's an invitation to a wedding.
Okay, so if my hypothetical is an invitation to join me in the 1950s through looking at this photo, you say one is different?
I say that that same clarity of the message isn't in that photo, but there are difficult lines to draw, and that may be an edge case, but this is not. We have a creator of speech and a very clear message.
It may be an edge case, meaning it could fall on either side. You're not sure?
I am sure, and that the message isn't in the product. It's not in the photograph. But even if this court were to find that it was, the court would still have to protect the speech. And the court could draw a line in a different place, as it has juxtaposed Loving and Obergefell in terms of the beliefs between same-sex marriage.
So just,
In Obergefell, did the court say that religious objections to same-sex marriage are the same thing as religious or other objections to people of color?
No, in fact, it said that decent and honorable people hold beliefs about marriage, believing that there's a gender-differentiated marriage and that that's based on reasonable religious and philosophical premises. When we review Loving, there's a very different...
Tell me how to write this decision for you that draws the line just on gay marriage, because that's what you seem to be saying right now, but draws a line that doesn't affect my example of a disabled person or an interracial couple. You're saying it's just because it's compelled speech.
I'm saying that the interracial couple, the disabled person, the lesbian graphic designer, the Democrat, the Republican, no one should be compelled to speak a message, and this court has never found a compelling interest that's narrowly tailored.
So you're saying a print shop, a web designer, a cake maker, a photographer, a jewelry maker, they can refuse to serve anyone they want to refuse because they have a deeply felt belief that taking pictures of Black couples, Black and white couples, taking pictures of disabled people, people are going to believe that they're speaking that message.
I'm not saying that at all. What I'm saying is that in every free speech case, the court looks first, is there speech? In many of the situations you raised, there would not be speech.
So why not? I'm saying your identical website, and I don't see a page in here where it says, I am speaking 303. That's on your personal website. It's not on the wedding website. I've asked you to show me where, in which pages, it's your message as opposed to the couple's message.
Every page is my client's message.
But
just as in a newspaper that hosts an op-ed written by someone
why
else.
does it
or Hurley, the parade.
But then why does an off-the-shelf website, the creator of an off-the-shelf website, is then speaking? That's what you're saying.
No, because the compelled speech doctrine doesn't apply once you've entered that speech into the stream of commerce. When the speech is completed, the compelled speech doctrine no longer applies. But in addition, there are 20 states that have filed an amicus brief in this case and said they're right now using their public accommodation laws to allow message-based protections as Hurley would require, and they're not experiencing these issues.
But you're not asking for that. You're saying,
Thanks for checking out Supreme Court Sunday here on the Urban Conservative. This Sunday, we're checking out arguments in 330 Creative. This is a case around speech rights and LGBTQ rights. Thanks for checking out the Urban Conservative here on Christmas Sunday. We hope you have a Merry Christmas and enjoyed the Supreme Court arguments from December 5th.
I don't think that's a fair characterization. The stipulated facts in this case are that Ms. Smith has LGBT clients. She serves them regularly. She has all kinds
Tell
of
me
clients.
how that's different, by the way. What you're basically saying is in our Oleg barbecue case, the company there said, I'll serve blacks, but only on a takeout window, not inside my restaurant, because that sends a message that I endorse integration.
Ms. Smith isn't looking to send a message through her conduct.
What you're saying is, I want to give gay couples a limited menu, not a full menu, just the way that luncheonette said.
No, just as this court found in Hurley, she's being asked to shape her speech by a third party. And it's about what messages she is creating. In Ollie's barbecue, they weren't engaging.
When I sit down to eat a meal by a full chef who creates this beautiful picture on a plate, why can't he say, I make specialized meals for my clients. I will not serve a black person. I won't serve a disabled person because they can't appreciate fully what I'm creating. That's basically what you're saying.
No, I don't think it is what I'm saying. We're conflating service and speech in that instance. A chef
But
isn't...
why is yours not a service?
May I answer the question?
Yes.
Because it is creating speech. And the public accommodation law is broad enough to ensure that we're not crushing consciences not just of Ms. Smith, but of her LGBT friends.
Thank you, counsel. If your client's website, you go, not so fast.
New way of doing it.
if your client's website was the same as it is, but the only indication of any limitation was a tagline at the end saying these services are for heterosexual couples only, could that constitutionally be applied under the Colorado statute?
The speech could be compelled if you're suggesting that she essentially has a no customers only sign, and that's exactly...
No, as in your case, no websites. No websites are available except for heterosexual couples.
For marriage?
Yeah, same thing.
Generally speaking, no. In Ms. Smith's particular case, all of her websites are created, they're original, customized to the story. And so in that instance, she believes same-sex marriage to be false and couldn't create the speech.
Okay, what if it said, I won't provide websites for anything other than heterosexual marriages because of religious reasons? Could that be covered? Or is it simply the invocation of religious basis for the objection that protects it from coverage under the statute?
The religious basis is not determinative here. This court has provided broad protection for religious speech, but it wouldn't matter. This compelled speech doctrine applies in a host of situations and cases that are not religious.
I guess I don't understand that answer. In other words, is it simply adding for religious reasons to the label that would change whether it can be regulated or not?
I think what's important is that the objection is to the message she's being asked to create. And so if she believes she's being asked to create a message that violates her convictions, whether those convictions are based on a moral reason or a religious reason, it would be protected.
Okay, thank you. Justice Thomas? Justice Alito? Justice Sotomayor? Justice Kagan?
Yeah, I wanted to take you back to my opening questions and then Justice Alito's question about how your case is different from my hypothetical. And maybe the way to sort of cut through some of this is to not make it a hypothetical and just ask about your client. So Mike and Mary go into your client. We love your graphics. We saw them someplace else. We love how this looks. Here's what we want. We want a standard site, our names, the picture, the hotels, the registry, you know, just that. And you say, okay, don't you?
Yes, assuming all the details line up with the message that she's willing to create.
Yeah, I mean, then they say, we don't want your scripture. But that's all right with you. They don't have to have scripture.
No, they don't.
Yeah, they can just have a standard site, right? Okay. So now it's not Mike and Mary. Now it's Mike and Mark, and they want the identical site. We saw Mike and Mary's site. We loved it. We're getting married, you know, all they want to change is the date maybe, or, their names, whatever. We loved it. And they don't get it. And the question, and you say no, right? You wouldn't be up there if you weren't going to say no, right? They can't get that site.
Yes, because the same words can even convey different meanings.
Yeah. So then, the difference is one couple is opposite sex, one couple is same sex. How is this, what are the different meanings? What is the speech that your client is expected, is required to provide in the way I expressed it to you?
The purpose of the websites is to celebrate an upcoming wedding. It's to announce a wedding. And
it is to announce a wedding. This is a standard site, there's not a whole lot of, gosh, isn't this great? It's just like, here's the registry, It's announcing the wedding, it's announcing where to get the hotel reservations, and so forth, right? So what speech is being, that's what websites do, just like it's what invitations do, right? So, next we'll have the stationer up there saying, we print the stationery, right? That would be the same. It is announcing the wedding. What's the speech that's been required of your client that I'm going to have lots of questions for these guys too. But in that context, what is the speech that is required of your client that would violate the First Amendment?
She believes that same-sex weddings contradict Scripture, and she's announcing a concept of marriage that she believes to be false. And in addition to that...
but that just sounds to me like I would be participating in a wedding, I would be, lending my services to a wedding. As Justice Sotomayor suggested, the florist, the baker, and the guy who provides the chairs are also providing the services in a wedding that they don't like. So why are they any different?
The person providing the chairs isn't providing speech, but when you are engaging in symbolic speech, whether that be through the creation of a custom wedding cake or a custom wedding website, you are creating speech.
Even though the site doesn't say anything about that. It doesn't say, wow, gay marriage is a wonderful thing. It doesn't even say, we're here to celebrate this wonderful marriage, in my hypothetical. It doesn't even say that.
Again, the announcement of the wedding itself is a concept that she believes to be false, and the entire purpose behind the compelled speech doctrine is to avoid these ends by avoiding these beginnings. It's to ensure that individuals don't speak messages that betray their conscience, and that applies just as much to the Democrat as to the LGBT or the Black Cross sculptor.
Thank you.
Justice Gorsuch?
So, counsel, we've spoken a little bit about how Colorado has handled this compelled speech question differently with respect to different messages, some that it prefers, others that it dislikes. I'm curious how other states have dealt with this conundrum besides Colorado, and which ones of those you think we should take account of.
20 states filed an amicus brief in support of Ms. Smith and expressed to this court that they're applying their public accommodation law to provide message-based protections, just like the court did in Hurley, following the same test that's being articulated today, and they've been doing it successfully. Yes, there are difficult line-drawing questions, but those are in every speech case, whether it's sleeping in the park or putting on an armband. The court doesn't have to resolve every single one of them, but we do have the rules, and we need the court to provide guidance, again, reaffirming public accommodation laws cannot compel speech creators, whether that's artistic expression with symbols or pure speech.
And just so I make sure I understood your colloquy with Justice Barrett, the objections to compelled speech here on religious grounds could include, in fact, do include some objections with respect to certain heterosexual marriages, that there are certain heterosexual unions that your client would not speak toward either. Is that correct?
Certainly, and that's in the stipulated facts in terms of she declines messages based on the message, and she has declined other projects based on the message that have nothing to do with same-sex marriage.
So the question isn't who, it's what?
Always.
Thank you.
Justice Kavanaugh?
From the briefs, I saw a lot of agreement, actually, between the parties in this case on basic legal principles. In your reply brief, page 15, you say that hairstylists, landscapers, plumbers, caterers, tailors, jewelers, and restaurants ordinarily wouldn't have First Amendment free speech right to decline to serve a same-sex wedding. At least that's how I read that reference in your brief. But you say artists are different, like publishing houses. And I think the other side, I'll hear from them, but agree that artists are different because of the First Amendment rights that artists possess. But then, at least as I read the briefs, the case comes down to a fairly narrow question of how do you characterize website designers? Are they more like the restaurants and the jewelers and the tailors, or are they more like the publishing houses and the other free speech analogs that are raised on the other side? That's what I took away from the briefs. A lot of
announcing anything, and art is different. And so while there may be agreement on that, what there also is a problem with Colorado's advancing theories that keep narrowing and providing alternatives. But in the end, one thing is certain: those who object to same-sex marriage and creating messages about them, those are the ones that can't speak. But everyone else seems to be able to do so under Colorado's theory. In addition, this court has already articulated how we determine whether speech is involved for an artist. And I think the court could follow those tests here with words, graphics, videos, and again, symbolic speech.
So for you, as there's an effort to protect both the equal rights of gay and lesbian people and same-sex couples, at the same time protect free speech rights, your line is look at whether the action of the business involves speech.
And the second line would be to look at what is the objection that the creator is asserting, and would that actually be in the final product, because that's how this court has ferreted out pretextual objections. So if a speech creator articulates an objection and it's not in that final photograph, the objection or the message isn't in there, that's one way we can know. Another is if they're refusing to serve an entire class of people and design other messages, none of which are true here. But
so if you win this case, if you prevail here, and the next case involves a caterer, at least your position here is that's different.
I won't be coming back with the caterer, but I will be coming back with perhaps a custom wedding cake or a cake that has a symbolic meaning to it.
Okay, but the caterer, the list of things that you had on page 15 of the reply brief, at least ordinarily, you had a caveat in there, but ordinarily wouldn't have the same right that your client here does, who's a website designer.
They wouldn't have a free speech right. And as in terms of your initial statement about the parties agreeing, I do think it's important on pages 17 and 32 of the United States brief, they're even conceding that it's a burden on a speaker to have to express a message that violates their convictions. They're just simply relabeling this or repackaging speech as a sale or conduct.
Thank you.
Justice Barrett?
So I think the questions that Justice Kagan asked you are hard because they seem like they're not creating. I mean, you're on your strongest ground when you're talking about her sitting down and designing and coming up with the graphics to customize them for the couple. So let me just clarify exactly what your position is on things that are already created in the past. What if it is plug and play? I don't know that much about website design, so I don't know how it could be plug and play. I'm sure it can be. She does the programming, the coding, she has stock pictures, and she sells that as a product.
Millennium TV, bridging communities worldwide. We broadcast diverse international content from Europe, Asia, Africa, and now right here in the USA. Watch us via Roku on your smart TV. Submit your own content to 1530entertainmentllc@gmail.com. Download the Millennium TV app from the App Store to stream our shows anywhere, anytime. Millennium TV.